Hello and welcome to the New Indian Express. The government refused to discuss the special intensive revision of electoral rules in the parliament. On Tuesday, Parliamentary Affairs Minister Kiren Rijiju said a discussion could not be allowed on two counts. One, the Election Commission is an autonomous institution and its matters could not be discussed in the parliament. Two, the issue electoral rolls revision is before the judiciary and hence it cannot be debated in the parliament. The opposition argued that both these contentions were wrong. Senior advocate and Congress MP Manish Tiwari said the concept of sub judice was outdated and didn't exist anymore.
Well, the Parliamentary Affairs Minister is absolutely wrong. Number one, there is no concept of sub judice any longer. The fundamental concept of sub judice was that when you had jury trials, that the jury should not get influenced. Therefore, the concept of sub judice, which forbade public discussion on any pending judicial matter or list, that was the whole concept of sub judice. Once jury trials were discontinued in this country, after the Nanavati case, and then for some years it went on, and finally in the 60s the jury trials were discontinued, there is absolutely no concept of sub judice any longer. So it's an outdated, archaic concept.
Let's listen to Supreme Court lawyer Nipun Saxena explaining the duality of a constitutional matter being sub judice.
So there is an inherent dichotomy that arises when you discuss proceedings inside Parliament before a court of law. On the judicial side, it is governed by a principle of sub judice, which essentially postulates that you cannot have a conversation or a debate or a deliberation on the floor of the parliament or even outside in a matter which is currently in session before a court of law, right? Which is perhaps the reason why the concerned minister said what he said. There is also a reverse, situation where the proceedings that have emanated on the floor of the parliament are also not to be dwelled into by judges or in courts, right? Or the proceedings of the floor of the parliament cannot be called into question or be a subject matter of adjudication before a court of law. That also is specifically, it finds its mention under Article 122 of the Constitution of India. Now, this is a situation where both sides respect each other's autonomy, sovereignty, and also try not to encroach into each other's domain. Right. Now, of course, some might want to say that a court, while exercising judicial review, can in fact entrench into or question the substratum of the proceedings that have been undertaken inside Parliament, but that's a separate issue. Right now, it's more of a rule of propriety that the court as well as the parliament do not sort of question each other's wisdom when a certain bill is pending consideration. It is, of course, once bill becomes law, then the courts are constitutionally mandated to check whether it offends one or more of the provisions of the constitution, or if it is violated of fundamental rights, or if it is in contravention to any other law. So on all three or four grounds, judicial review is available. But insofar as until such time that the bill becomes a law, it is within the domain of the parliament to discuss and deliberate upon it, because what happens is that multiple times the speeches of ministers are quoted as to identify the purpose of the legislation, and therefore it becomes important that while a matter is already sub judice, there are no statements which are issued or statements made on the floor of the parliament, because that may have some bearing on the outcome of the case.